Does your landlord want to evict you? You think you might just change the locks? Well, in New York City, it's illegal for a landlord to change the locks unless he gets a judgment from housing court. Chances are your landlord knows this. Your landlord is a pro. He's been to housing court many times. Most tenants don't even know where housing court is. That's why I made this video. I'll guide you to the resources and information you need so that when it comes time for you to appear in court, you'll be prepared to fight for your apartment. Now, a lot of people have this misconception that they're just going to be able to present their case in front of the judge in whatever words they see fit, and then the case will be over. Now, you should know that very rarely do you just go to your first court appearance and present your case and go home. And that's why one of the most important questions I'm going to be able to help you with is, should you hire a lawyer? Now, I am a lawyer, so of course I'm going to say that you'll get the best help if you do have representation. But you should know that hundreds of tenants represent themselves in housing court effectively without hiring an attorney. Even if you do hire an attorney, it's going to be important for you to get this information, because as somebody who represents a lot of tenants, I can tell you that the client is the most important part of the defense team. It used to be that when the tenant owed rent, the landlord could hold any goods or chattels found on the tenant's premises until the tenant paid the rent. This type of action was called distress, for obvious reasons. When there wasn't enough stuff in the apartment to make up for the rent, the landlord could do a lawsuit known as an ejectment proceeding. But it could take months, if not years, to resolve this type of suit. And you know landlords weren't going to tolerate that. So in 1820, they created what's known as a summary proceeding. This law is now called Article 7 of the Real Property Actions and Proceedings Law, the RPAPL. All housing court proceedings are summary proceedings. The summary proceeding was supposed to give landlords a proceeding that is quick and cheap. Well, we know that in housing court it's not always cheap and generally not quick. Nevertheless, it's much more efficient than what we had before. Instead of waiting months for a court date, the parties could get the first court date in a matter of days. Landlords loved it. Where ejectment moved like a horse and buggy, the summary proceeding got you to eviction as fast as a subway train. Today, the number of housing court cases in New York City alone is larger than the number of lawsuits filed in all the federal courts in the United States. Landlords jealously guard their right to do a summary proceeding, but there's a catch. In order for the housing court to have jurisdiction, the landlord has to prove that all the technical requirements are met. This is in addition to all the legal requirements that are already involved in renting apartments in New York. When the landlord fails to satisfy any of these legal picadillos, the judge is often forced to dismiss the landlord's case and save you from eviction. To find out if you have grounds to have your landlord's case dismissed, you have to do an investigation. The most important question regarding any apartment in New York is whether it is rent-controlled or rent-stabilized. It's very easy to look at a lease and tell if it's rent-controlled or possibly rent-stabilized. But even if your landlord fails to give you a stabilized lease, you might still be rent-stabilized. If you are in a building of 6 or more rental apartments built before 1974, why wouldn't your apartment be rent-stabilized? If you don't know the answer to that question, then you should go and make an effort to find out. Now the question is, if you're rent stabilized or if you're rent controlled, what is the legal rent? It is very common for tenants to find that the landlord made them sign a lease for an illegal rent, in which case you could be owed a lot of money. So the next step is to call DHCR and obtain a rent history for your apartment. Then you can take that rent history to a lawyer or tenant advocate for advice. I've gotten many cases dismissed because the action was filed under the wrong name. How does that happen? The vast majority of buildings are owned by corporations, and sometimes the principals use more than one corporate name at a time, so they often make a mistake. you have to see the current deed to your building. Okay, so where do you find the deed? If you're in the Stone Age, you go to the office of the city register in your borough. But online, all you have to do is go to Google and type in ACRIS. In order to get your deed using ACRIS, you need the block and lot number of your building. This is not very complicated. First, when you get to ACRIS, you need to click this link and type in the street address in this form. The block and lot number should appear at the bottom half of the screen. Then you click Main Options, which takes you back to the same menu, and then you can type in the block and lot on this link. And then just like that, you get your deed. Housing code violations are the apartment conditions that affect tenants' health and safety. It is a prepared tenant who comes to a community office armed with a violations printout. You can get a violations printout here at the Department of Housing Preservation and Development, or you can go to Google and type in HPD. While you're here, you should check out the multiple dwelling registration for your building. If the registration is expired or invalid on the day of trial, the judge could dismiss your landlord's case. You may suspect that your apartment was illegally created from commercial space, perhaps even a long time ago. The certificate of occupancy determines whether the landlord is legally permitted to use your space for residential purposes. If the certificate of occupancy is not up to date, your apartment could be illegal. Multiple Dwelling Law Section 301 prohibits a landlord from collecting rent for an illegal apartment. Any rent suit for that apartment would almost automatically get dismissed.